welcome to the Arbitration Conversation. This is a true treat. We have one of the most prolific and long-standing scholars in arbitration, and especially employment and labor arbitration. We have Michael Z. Green from Texas A&M University, where he is a law professor. He also directs the workplace law program, and he is a labor and employment arbitrator and professor of arbitration. He's also a member of the National Academy of Arbitrators and the AAA Labor Panel, as well as the FMCS, I always get that wrong, Labor Arbitration Panel. So in other words, he's a very avid and active labor arbitrator. And he also is very prolific on issues regarding race in dispute resolution, especially dispute resolution of workplace matters. So Michael, thank you so much for taking time with us today.
Oh, thank you, Amy. I'm very happy to be on this. When you asked me, I looked on the website and I said, this is a veritable who's who of people in arbitration. And to even be on the list is just an honor to be asked. And with you leading this, I think that I'm very proud to be here today.
Well, we're just super thankful because you've been writing about issues of race and arbitration for a long time. And you were one of the first people to really come out with some very strong and important articles on the topic. So there's really no better person to have on this than to have you talking about race in arbitration at the midpoint of 2020, which is where we are right now in the midst of a pandemic on top of that.
Right.
So I guess to start off, my first question is, I see that you've been really active in these debates, and with the senseless death of George Floyd in Minnesota and Black Lives Matter and all that's happening, maybe you could speak about sort of your views and what is happening and how that even relates to arbitration.
Sure. Well, one of the things, and you mentioned how I've been writing about this, but I had a 2017 article in the SMU Law Review called Reconsidering Prejudice and Alternative Dispute Resolution for Black Work Matters. And there, certainly the Black Lives Matter movement has certainly dealt with a number of issues of young Black men who have been killed in police shootings, and the whole Ferguson, Missouri incident really sparked a lot of that. But one of the things I wanted to highlight with the football player Colin Kaepernick, who was then taking a knee during the national anthem, and that was really a prominent news story at the time. I wanted to highlight how that issue, when it comes into the workplace, how people might deal with it. And so with what has now happened with George Floyd, people are kind of coming back to that article. In fact, I think on Twitter, SMU Law Review started tweeting that I had published that article, and people were bringing it up again a couple of years later. And in that article, what I tried to highlight are that if you have issues of race that come up in the workplace, and even now I'm seeing it again with people who are saying, because of the George Floyd matter, we want to be sensitive to how we address these issues in the workplace as they come up. And so I started to look at it from alternative dispute resolution perspectives. And there's one section of the article, I kind of coined these terms where I start off saying negotiating while Black. And there I highlight some critical race issues regarding stereotype threat and covering that people may not be understanding when they're dealing with people in the workplace. And then I went to mediating while Black, and I talk about the lack of mediators and people who might be able to empathize or understand some of those dynamics, especially someone who is basically under the throes of the Black Lives Matter movement in our society, and helping people understand that. And then lastly, and certainly more directly with our topic, I had a section called Arbitrating While Black. And there I was highlighting a lot of the concerns when an employee brings a claim of race discrimination and then gets subjected to a dispute resolution process that on its face might seem neutral, might seem, some of these terms get used, colorblind, or we're in a post-racial part of society, and they don't see either implicit bias or some of these kind of things that suggest behavior that is not normal to other people, but they think that it somehow suggests maybe some misdeeds or some justification for actions they're taking. And as I said, like stereotype threat or covering in the workplace, not wanting to basically show your identity as a person of color so that way you fit in more rather than raising issues. And a lot of workplace dispute resolution is about bringing claims forward and processing these claims and expecting that, well, why didn't they say something? And if you're talking about harassment, why didn't you bring this to people's attention? And certainly with the Me Too movement also kind of joining in with this, we're seeing now where people are understanding this a little bit more, and certainly why with Black Lives Matter, how that might be an important issue.
Oh yeah, 100%. I mean, there's so much good stuff in this article. In looking at it, also maybe you were also talking about Janice Tootie Jackson and some of her statements here within the article, and I really welcome people to check that out. It's the SMU Law Review from 2017, because it's really a fantastic article and it adds a great deal to the scholarship. I'm not surprised that they're retweeting it. That's funny. So in moving, but also in thinking about, because from your sort of labor and employment, now kind of putting that hat on, which is tremendously important, because we see that right now with police arbitration and with different issues regarding police discipline, and how arbitration actually is very relevant with respect to those issues. Maybe you could speak to that and explain why we should care and why it matters.
Well, certainly, if you think about the George Floyd matter and what happened there, and certain people asked me this question too when it first happened. I mean, I was just so shocked by kind of the utter disregard for humanity that was involved there. And yet there were news stories that came out suggesting the police officer involved had had prior disciplinary actions and nothing happened. And I actually was watching a news story where African-American mayor of St. Paul was talking about arbitration is the problem here. And so as an arbitrator, of course, that, raised my hackles a little bit. I looked up and said, arbitration's the problem. How could arbitration be the problem? And so I started to think about what that could mean. And by the way, I do serve as a labor arbitrator. I've been on a police panel before, and I've dealt with some police cases. But I think the issue when you just say, is it arbitration? Arbitration is the problem here. And I even started to look at some websites and I would see these horrific stories. They've been portrayed horrifically in the media. This person did all these things. They maybe shot someone who was handcuffed or did something or used too much force. And it sounds horrific. And you would say, how in the world could that person have gotten reinstated? But labor arbitrators are professionals. They know they can't just make decisions based upon something that's not a creature of the contract that creates their authority to be able to resolve the dispute. And many times the problem has to do with, in a labor agreement, either the collective bargaining agreement has given so many rights to the officers involved that there's a rush to judgment sometimes. They kind of ignore a lot of the rights that they've given to, in terms of the process they're supposed to go through and things they're supposed to do. And so in that instance, it's not arbitration that's at fault. It's really the police department, the leadership that hasn't followed their own procedures, that have, maybe they've gotten some political pressure, some outside pressure, and they say, we better take some disciplinary action. And then you get into arbitration and they show the union representing these officers is able to show so much disparate treatment. So many other people who did these exact same things in the police department didn't do anything. Now, people are concerned. And I think one of the ways to deal with this, and I kind of talked a little bit about this in my SMU article, kind of thinking of broader collaborative processes. If you think from a critical race perspective, Derek Bell is one of the prominent leaders of the critical race movement. And he always talked about finding common interest He referred to it as a convergence interest theory, that if you're going to address the concerns of people of color, you also have to find ways that it meshes with other people's interests so that they can converge them. And I think that if we could get some of the police unions to be at the forefront of maybe suggesting some of the changes, and then working with police departments, certainly you have to be concerned about a police officer who is unfairly disciplined, but they're also in the community to protect and serve. And there's concerns, certainly from the numbers that have been raised by Black Lives Matter, to think about how can we be also trying to address that and be at the forefront. Now, some of these involve state laws, you know, civil service reform and things of that nature that have to come into play. Some jurisdictions don't allow personnel issues to be negotiated in collective bargaining agreements. Others allow a host of things. And some of these unions have become very powerful in their negotiating power, and there's nothing illegal about that. But maybe you have to address laws. But just to say arbitration is the problem, that in itself really reads too much into the story. And every decision that I've actually been able to look at, the arbitrator is very thorough in explaining exactly why they had to reinstate them or make the discipline less. And it's not just because they're just sitting there going, yeah, I don't really care here about the terrible things this person did. It's really the way it's framed.
Yeah, that's such a good point. And the truth is, actually, labor arbitration, a lot of those opinions are available. I
Yeah.
know with the AAA, don't they publish those opinions? So it's not quite as secretive as claimed. So those are really important points. The other thing I really like is your discussion about interest-based and collaborative processes. I think that makes a lot of sense. Those are
Yeah.
really good points.
Now,
You know, you've
some
been
of the public sector aren't published as much sometimes, but usually you can get them usually through public information request. There's a public reporter in Texas. I mean, I had one of my students was talking to me, a research assistant was telling me, was quoting one of my decisions in a police case. And I said, how did you get that? Where did you get that from? And it was someone orders these through public information requests and then does these little summaries about the decisions. So that's just another way to get the decisions. So you're right about the kind of the confidentiality and privacy. Those decisions can be out there. And I found a few like myself, I was interested in what was going on in Minnesota and found one from a prominent arbitrator and read the decision. And I thought, yeah, based the way that they were describing it, it sounded horrible. How could this arbitrator reinstate it? And then I read it and I'm like, yeah, it makes sense why they had to reinstate him. So.
Yeah, yeah. That's great though. That's kind of funny though that your student was quoting you. But
Yeah, she was telling me, oh, I like this decision and what you said. And I said, what do you mean? And I didn't even know what they're talking about. I thought they were talking about some kind of private sector that maybe was published through AAA that I just didn't know about. And they started talking about it, and it was a police officer case. And I said, what? How do you know about that? And then start telling me, oh yeah, there's this reporter out there, and they get the decisions, and they so I was like, oh, I didn't even know that myself, because I was basically thinking this is all private. I mean, it is a public entity, and certainly if you wanted to do a request, I knew you could do that, but I had no idea somebody was actually doing that and then putting it out there in their own little reporter and describing the decisions. So, and I know, like, I believe in Washington, state of Washington, I've seen a lot of their public sector decisions are online for the arbitrators. So you can read the decisions, but more often than not, you certainly have somebody on one side that's unhappy, but the arbitrator is their livelihood. So they have to explain and give a rationale for what they're doing and why, or else they won't be employed in the business too long.
Yeah, because it's competitive to be a labor arbitrator. So you're not going to want to make a lot of mistakes because then you won't get selected. I mean, because you have to work. I mean, it takes a lot. I know. I mean, for people to get to the level of you are to be part of the National Academy of Arbitrators, I mean, those are very competitive positions.
Yeah.
So it kind of brings me, I guess, to the next article. Again, you're very prolific. So I also saw in the Fordham Law Review, and in fact, I had the pleasure of seeing you present live in New York at the actual Fordham event. It was a law review symposium before the pandemic hit. And you had an article that came out in that symposium, which is arbitrarily selecting Black arbitrators, which is kind of a provocative title. So I wanted to ask you about that article and and how it kind of reflects on what's happening now as we are at the midpoint of 2020 and talking about race in arbitration in particular.
Sure. I think in general, so with that article, one of the things I was trying to highlight is there's lots of people who speak psalms to diversity in arbitration and making sure that when you select arbitrators, that there are opportunities for more women and people of color to serve in those roles. And certainly I remember when I was looking on your website, I know that you've had a couple of people who have kind of touched upon this subject a little bit. I know Ben Davis talked a little bit about in the international commercial arbitration setting, and certainly more directly to what I was looking at, certainly Sarah Cole at Ohio State, I know has an article coming out. And in some ways, she and I are both looking at the same issue, but maybe a little bit different suggestions regarding it. And I start off with the premise that a lot of the argument has been that this is a supply problem. We need to find more people who are women and people of color who have the skills, the background to serve in these positions. And I certainly think that is still an ongoing issue, but I know there have been a lot of proactive programs aimed at dealing with that very issue. When I became a labor arbitrator, Floyd Weatherspoon at Capital University was hosting a program for minorities in dispute resolution. One of the things to get on the labor arbitrations, the FMCS panel, is you have to have some of their training. And he had an FMCS training course at Capital, and there were over 20 African-American people of color who had all the background to serve as labor arbitrators. And a couple of them have now become members of the National Academy, including me. And when you looked at that, I thought, this doesn't sound like a supply issue. It's really, are these people getting selected? And part of the problem then with getting selected raises what I talk about in the article as kind of a gatekeeper problem, and really how there are perverse incentives for the people who are making the decisions and selecting the arbitrator to really pick people they know, they're familiar with, who are kind of time tested. And that tends to be, for most of the data, is probably going to be older white males that they're familiar with and tested with. A lot of that has to do with the selection process. And so you contact a neutral service provider, someone like AAA, and ask for a panel. And you get a panel, might have 7 people on it, a little bit of biographical information about who they are, and you can certainly look that up too. And usually parties agree to strike. They decide who goes first. One party strikes a name, another party strikes the next, and then the last person left becomes the arbitrator. Well, that means that the parties are playing a very intricate role in the actual final selection. So imagine the gatekeeper, the advocate working for some major corporation who espouses concerns about diversity and maybe has pledged statements about diversity. But when it comes down to that particular dispute, their motivation is to prevail and win the dispute. So they're not thinking like, please select a diverse arbitrator for me. They're thinking, please select an arbitrator who's going to rule in our favor. That dynamic affects the demand issue. So you can have a pool of all of these very qualified women, people of color, but if the decision maker is got to justify why they ultimately selected someone, or better yet, if you go through this 7 number or a 9 or odd number process, I'm striking X because I don't know them. I don't know how they're going to rule in our favor. Sure, they look diverse, or maybe they're diverse and I don't know it, or whatever it is, and I struck the most diverse person on the panel. But it's not because, right? This gets into the colorblind thinking. It's not because of their race. It's not because of their gender. It was because I don't know them. And if I pick them and they rule in my favor, how do I justify that? And so that process is what I'm trying to get at in the article. And what I end up suggesting, and I know Sarah mentioned this a little bit, but what I end up suggesting is that you eventually replicate how the federal court system works. And the parties don't actually literally get to pick who their judge is. So you file a claim, and it's described more in the article, but certainly there's a way in which the clerk system ends up randomly assigning the judge. Now, it's not complete randomization because they look at some factors where it might be better, maybe it's a senior judge we need for this. And I suggest this in the article. I suggest that the service providers, and some of them are trying to do this anyway to make the pools more diverse, they could put in a little algorithm that starts off with a certain percentage of diversity in the panel that they draw from, and then they select who the arbitrator is. So when the parties contact AAA and say, I need an arbitrator for this employment discrimination dispute, we've got an agreement that says use the AAA employment rules, give us an arbitrator. AAA responds back and says, here's the arbitrator for you. And then you don't have the gatekeeper problem. You can't say, well, you selected this person. No, we used AAA. AAA did all of the vetting. They made sure that people have the qualifications to even be on their panel, and then they randomly selected them. So I call it arbitrarily selecting Black arbitrator. Not so arbitrary, really, but I like the alliteration.
Yeah.
And so,
I do too.
and so because of that, you end up randomly getting more diverse people to deal with what I refer to as the demand problem.
See, and I have to say that resonates. I actually also think it's a demand problem. And I think the way you describe it is exactly right. I can even think when I was in practice and when we would select arbitrators, it was, you went with who you knew. You know, it wasn't about, you just went with that arbitrator because you already knew that arbitrator. And certainly I agree, when I did my AAA training, there were many women and people of color, but I have yet to be selected. So I think it is a demand problem in a lot of these situations. So I think that's a really important point. And I can imagine a hypothetical as you talk about, because you can choose, right, that somebody is an expert in these different things, right? And so if they've already gone through the training, they actually went over the hurdles to actually get on the panel, let's say with the AAA or whoever else. And then you would be able to choose for different areas of expertise and maybe levels of experience. That would make a lot of sense. Has this ever been, do you know of any arbitration groups or anybody that's actually using this to any extent?
Well, no, but one of the things that I suggested, and I think that Sarah kind of talks a little bit about this in her paper. She talks about, like, having balance. Also, I think Richard Frankelman mentioned this a little bit too, being concerned about power differentials, right? So who's making these decisions? You need someone to kind of level off the playing field. And so in labor arbitration, certainly unions balance off what employers are doing. When you get to this is more of a concern to me when it's the individual employee arbitration or so-called mandatory arbitration systems where this occurs. And there really is no group out there, right? I think Sarah talked about maybe getting the plaintiffs' attorneys group maybe to do that more. And certainly there's some motivation, maybe a group like the National Employment Lawyers Association, which is the plaintiffs' employment bar, might do this. But what I suggested is, I'm appealing to those businesses, those employers that have all of these diversity pledges and all these things. They say they care about diversity, that and get all the constituencies together and add a segment to the due process protocol, so that these neutral service providers who are parties to the due process protocols, they wouldn't accept a request for an arbitration there unless they then applied this new methodology. So that's my suggestion. Now, in the article, I go through an example of a hypothetical where I list kind of 7 people and they have different backgrounds. And the real problem with what goes on now is that there is no regulation of this. So when you make decisions, as you said, I could certainly say it's because I don't know you, I don't know, I have no familiarity, but it could also be, I could just be openly and blatantly saying, that's a woman. I don't want this woman on here. And I don't have to explain it. That's an African American. I don't want the African American arbitrator deciding a claim against me as an employer when there's an African American plaintiff. I don't want that, which sounds offensive to us if we're talking about mandatory arbitration, because the employer is the party that regulated it, moved it out of the court system into private arbitration through their bargaining power. And yet they wouldn't be able to do that in the court system. They wouldn't be able to say, I don't want this juror to, I don't want a black juror because there's a black plaintiff in the case, but they can certainly say, I don't want a black arbitrator, and there's nothing that regulates it. So that's why I started looking at it as certainly those businesses are all touting diversity. And there's, for years, people have been talking about this is a problem and we need to do this. And they focused on the supply side. Oh, we got to get more people. And you know, certain people like JAMS draws a lot of their arbitrators more from like former judges and partners at law firms. And I kind of mentioned that in the article. Well, then you've automatically shrunk the pool of women and people of color who can even feed into that. And maybe you start thinking more expansively, but if you have this due process protocol where all of the major service providers have agreed to it, you're certainly going to have some businesses and entities that are not going to want to do that. But the whole benefit of using a neutral service provider, they reduce your transaction cost, right? They do all the vetting for you. They find all the experienced people who have the backgrounds and all of that. So there's really a benefit to using them. And if all the constituencies agree that, you know, this process has been a little bit infected with possibly implicit bias or whatever, or just the fact that, you know, the gatekeepers have this perverse incentive to only select people they already know, then this kind of gets around that problem by trying to address it in this way.
Yeah,
So.
no, I mean, especially I feel like we're at this moment, you know, we're at this moment in 2020 where maybe we're finally going to see a change of this type. I
Yeah.
mean, I think this would make a lot of sense, because especially as you say, I mean, these groups, they're doing the vetting. So you already have qualified professionals, and especially in employment. That was such a good point. I hadn't really thought about it until I was kind of wrapping my brain around thinking about, especially with mandatory arbitration clauses in these employment cases.
Yeah. Yeah, because of those clauses, right? If I'm an individual employee, and think about it at this point in time, right? The midpoint of 2020, all the things. By the way, even the pandemic has had some really detrimental effects on people of color.
Mm-hmm.
So you have people of color who are experiencing major health issues, and they're confronted with the aspects of what happened to George Floyd and the protests and all of these things, and they're in the workplace and they have some kind of an incident and somehow they get disciplined for it. And then they find out, well, the chances that I would even have an arbitrator who's the final decision maker would be somebody who might understand concepts of implicit bias or stereotype threat or covering as the justification for why I acted in the way which I did. It was not some kind of misconduct. It was not some attempt to violate employer rules. Then it suggests that that's an unfair system. And I think, as Ben mentioned about the international, maybe because of what is going on now, people are much more willing to start to take these things on, because it's really a new problem.
Well, it's time. It's time. So let's, you know, I hope.
Yes.
Well, gosh, Michael, this has been a really, really great conversation. I could talk to you forever on this. Thank you so much for taking the time with us today. This has just been tremendous. You have so much to offer. I tell everybody, read the articles, SMU 2017, Fordham Law Review 2019, fantastic articles. Thank
Actually,
you so much for sharing.
2020 for the Fordham article.
2020, you're right. I should know that.
Yeah. So,
My brain is, exactly. Well,
yeah.
listen, thank you.
Thank
Good
you. It's
stuff.
my pleasure to be here. And I hope I'm worthy to be on the list of all the great people that you have on your roster.
Oh, of course. Are you serious? Of course, you have to be on it for sure. Otherwise, it wouldn't even be the arbitration conversation. So
all right.
thank you.